Your case doesn't end with the verdict. Understanding post-trial options is crucial. I'm Professor James Mitchell, appellate specialist and law professor, and I'm going to show you how to protect your victory or salvage defeat through New York's post-trial and appellate procedures. The most important deadline in appellate practice is the 30-day rule. You have exactly 30 days from entry of judgment to file your notice of appeal, not from the verdict, not from when you receive notice, from when the judgment is entered in the clerk's office. Miss this deadline, and your appeal rights are gone forever. But before you appeal, consider post-trial motions that might give you the relief you need without the expense and delay of an appeal. Motion for judgment, notwithstanding the verdict under CPLR 4404, lets you challenge a jury verdict that no reasonable jury could have reached based on the evidence. The JNOV standard is high. You must show that the evidence so preponderated in your favor that the verdict could not have been reached on any fair interpretation of the evidence. It's not enough that you disagree with the jury's decision. You need to demonstrate that reasonable minds could not differ. Motion for a new trial under CPLR 4404 gives you broader grounds. Errors in jury instruction, misconduct by opposing counsel, newly discovered evidence, or a verdict that's against the weight of the evidence can all justify a new trial. The weight of the evidence standard is more forgiving than the JNOV standard. Here's a strategic consideration from my appellate practice. Sometimes a new trial motion is better than an appeal. New trials happen in months, not years. Appeals can take 2 years or more, and you might win the appeal only to face a new trial anyway. For appeals, understand New York's appellate structure. Most appeals go to the appellate division of the department where your case was tried. The Court of Appeals is discretionary for most cases. They choose which cases to hear based on statewide importance. Not every order is appealable. Final judgments are always appealable, but interlocutory orders require specific authorization. CPLR 5701 lists appealable orders. But the key principle is that you generally cannot appeal until the case is finished, unless the order involves constitutional rights or effectively ends the litigation. The record on appeal is crucial and expensive. You need transcripts of all proceedings you want the appellate court to consider. Court reporters charge by the page, and trial transcripts can cost thousands of dollars. Budget for this early and order transcripts promptly after adverse rulings. Brief writing separates good appellate lawyers from great ones. Your statement of facts must be accurate and persuasive while acknowledging unfavorable evidence. Don't bury important facts in footnotes or hope the court won't notice problems in your case. For your legal argument, start with your strongest point. Appellate judges often decide cases based on the first issue they find dispositive. Lead with winners, not warm-up arguments. Standard of review controls everything in appellate practice. Questions of law get de novo review. The appellate court gives no deference to the trial court. Factual findings get clearly erroneous review, which is very deferential. Discretionary rulings like evidence decisions get abuse of discretion review. Frame your appeal around the most favorable standard of review. If you're challenging a legal ruling, emphasize that it's a pure question of law deserving no deference. If you're attacking factual findings, you need to show clear error supported by the record. Oral argument in the appellate division is typically brief, often just 15 minutes per side. Prepare for interruptions and questions. Don't read your brief to the court. Use the time to address their concerns and emphasize your strongest points. Here's what I've learned from 20 years of appellate practice. Most appeals are lost, not won. The appellate court starts with a presumption that the trial court got it right. Your job is to overcome that presumption with compelling legal arguments and clear record citations. Enforcement of judgments requires its own expertise. Winning a judgment means nothing if you can't collect it. New York gives you powerful collection tools, restraining notices, asset discovery, and contempt proceedings, but you must use them correctly. Restraining notices under CPLR 5,222 freeze bank accounts and other assets, but they're only effective if served before the debtor moves money. Asset discovery under CPLR 5,223 lets you examine the judgment debtor about their finances under oath. For contempt proceedings, you need to show willful violation of a court order. Document everything: missed payments, hidden assets, violation of disclosure orders. Courts take contempt seriously, but only when you prove your case clearly. My final advice on post-trial strategy: plan your post-trial options during trial. Preserve objections for appeal, document misconduct for new trial motions, and gather asset information for enforcement. The decisions you make during trial determine your post-trial options. Remember that most cases end with trial, not appeal. But when appeals are necessary, thorough preparation and strategic thinking can turn defeats into victories or protect hard-won trial wins. That completes our comprehensive tour of New York civil procedure from filing to final resolution.